like to reserve 3 minutes for rebuttal. This matter stems from a search warrant that was executed on another individual by the name of Tyrone in reference to trafficking in drugs through the Cuyahoga County Sheriff's Office use of a confidential informant. During the execution of the search warrant at Ms. Bell's residence, the detectives of that agency had a conversation with her regarding whether or not she would cooperate with them in assisting in other investigations of other drug dealers and her cooperation with that. She provided information to the detectives that a Tyrone Jackson, who is the defendant and the appellee in this matter, had a quantity of heroin that he was holding for her, and she agreed at that point to participate in a controlled pickup of those drugs from Mr. Jackson. Ms. Bell provided information as to Jackson's residence, and actually she was unable to provide a specific address for him, and she drove the detectives over to the residence so they were able to obtain the address that would be utilized, that he held the drugs at for her. In the evening, on the same day that the search warrant was executed on her residence, she met detectives at a Super 8 motel. She was wired. She was searched for drugs. Her person was searched for drugs and money, as well as the vehicle in which she was driving. She made a phone call to Jackson indicating she wanted to pick up the drugs, and he eventually called her back and told her, I'm at home. At that point, detectives then set up surveillance on the residence of Jackson, as well as a car followed Miss Bell to his residence. She said that normally she would park in the driveway of his residence, however, there was a car there, so she parked on the street. Surveillance to confirm that. A male that was fitting the description of Jackson that Miss Bell provided exited the residence, provided her with a bag, and then he returned to the residence. Miss Bell was then also followed from Jackson's residence back to the Super 8 motel, where she provided that bag to the detectives. A field test was conducted, and the substance contained did a presumptive test for positive of heroin.
Excuse me for just interrupting.
Yes, Your Honor.
Will the record before the court have the a transcript or video of either the phone calls or the conversation that Bill had with the officers leading up to going to the Jackson's residence?
There was a CD, an audio CD that was actually made. It was not a video, a recording or any sort of transcript, to my knowledge, of the actual CD itself. But it is my belief that that was captured as a part of the audio recording that she was mic'd during that time.
So would that include her phone call to him?
I believe it would have included her end of the phone call. I cannot say that it actually included his voice on the line or anything of that nature.
So it would have captured the phone call as well as their discussion when she was sitting in the car?
Oh, correct. It had a portion of her. She actually said the directions that as she was going, what turns she was making as she was driving. When she actually made it to the residence, of her calling presumably Jackson, because again, it would not have, I don't believe it captured the other end of the phone call, but saying that she was at the residence, and then, you know, somebody coming out and, you know, providing that to her.
What about prior to that, when you said that they executed a search warrant on her at her home?
Correct, Your Honor.
And was that recorded on that CD as well?
Not to my knowledge, no, Your Honor. That portion of it was separate because it was, I believe that the actual search warrant of her residence was earlier that morning, in the early morning hours, and this actually took place with regard to Jackson later on that evening. Jackson did file a motion to suppress on 4 arguments. The first 3 arguments were eventually rejected by the trial court, the 4th being to address falsehoods or that were contained within the search warrant. The motion itself did not point to any specific areas of the affidavit itself, which they alleged to be false, and eventually, at a later point, was supplemented by an affidavit by Ms. Bell. In the first assignment of error, the state contends that that hearing, based upon that fourth argument contained within Mr. Jackson's motion to suppress, was erroneously held. That Mr. Jackson did not meet the burden to actually allow for the trial court to hold a hearing with regard to that argument. A defendant must make an offer of proof with regard to the information that he alleges was false and point to specific areas of the affidavit which he alleges to be false. However, in this matter, those specific requirements were not met. In his motion itself, it only contained case law with regard to a knowingly false made statement or a reckless disregard for the truth. It did not point to what areas of the affidavit itself he was addressing, and the actual affidavit that was provided by Ms. Bell seemed to allude to her agreement to participate with the Cuyahoga County Sheriff's Office and her agreement to conduct a controlled purchase or controlled delivery of drugs. The state would argue that that information in and of itself does not meet the burden that would have allowed the trial court to actually conduct a hearing on this matter. Now, the court did in fact state that the defendant met this burden and therefore a hearing was to be held on the matter. And that goes to the state's second assignment of error. At that hearing, Ms. Bell did appear. However, during the hearing, she asserted her Fifth Amendment rights against her Fifth Amendment rights with regard to all but one question that was posed to her at the hearing. And therefore, the state requested some guidance as to what exactly the hearing would be limited to. What information is it that the state had the burden of disproving with regard to that Frank's hearing. And the trial court did in fact limit that to the information that was disputed within Ms. Bell's affidavit. And again, that affidavit was very limited and because of the fact that Ms. Bell decided to assert her Fifth Amendment rights, was not able to be fleshed out further at the hearing. So the state was left with these two paragraphs within that affidavit with regarding to her agreement to cooperate, her agreement to participate.
So she was conveyed to the Frank's hearing and the only thing she would answer was one question.
Just that she read over the affidavit and that was it. She did not answer any substantive questions with regard to her participation with the Cuyahoga County Sheriff's Office. Therefore, based upon the information that was actually contained within the affidavit, the state presented several detectives to rebut that information of her agreement to participate. The detectives indicated that at the time of the search warrant, they did speak to Ms. Bell, that Ms. Bell provided the information to the detectives with regard to Mr. Jackson, that she drove them over to his residence to allow them to obtain information about the address, that she was mic'd during the controlled pickup of the drugs, and that she ultimately did turn those drugs over to the Cuyahoga County Sheriff's Office. Therefore, the state would submit that it in fact did provide sufficient information to rebut the information that was contained in Ms. Bell's affidavit, and therefore that the trial court erred in finding any sort of deliberate falsehood or reckless disregard to the truth with regard to the information that was actually raised by Mr. Jackson.
So how and where did this issue of the falsehood of the one detective, or he wasn't a detective, he was a sheriff's deputy.
Yes, Your Honor.
How did that come before the court? Did he testify at the hearing?
He did in fact testify at the hearing, Your Honor, and that was, the state was attempting to obviously provide information about her cooperation with their investigation, and he did in fact testify, as well as other detectives that were involved with the investigation into Mr. Jackson, and in fact Ms. Bell as well.
And the court presumably did not believe his testimony. Agree?
The court determined that the information that was provided at the hearing did not comport with the, I guess, all of the information that was contained within the affidavit itself.
In his affidavit?
Correct, Your Honor. Yes, in his, correct.
Well, wasn't his affidavit constructed 2 days after the actual search was performed?
Yes, it was, there was a couple days, correct, Your Honor, in between the execution of the search warrant at Ms. Bell's residence to the actual signing of the search warrant for Mr. Jackson's residence. So it appears that most of the activity with regard to Ms. Bell took place on January 19th, and then the actual search warrant itself was signed on the 21st of January.
You're very close to your 3 minutes.
I will go ahead and reserve the rest of that for a moment, Your Honor. Thank you.
Thank you.
Counsel, Your Honors, may it please the court, I'm so used to being on the other side of this, I was going to ask to reserve some time to rebut as well. I won't. Your Honors, I think there's been some questions that, and I wanted Judge Schaefer to start with what was just said. The warrant that, or what was queried of counsel, the warrant regarding Ms. Bell, having occurred on the 19th, culminated in 2 days of investigation in between the 21st warrant regarding the Belfield address that ultimately was determined to have been Mr. Jackson's. In between that time, Detective Monteleone, who served as the affiant regarding the affidavit, was also acting in a supervisory capacity amongst the other detectives who testified at trial, and had consolidated or indoctrinated, obviously, their reporting and their investigating what happened. There was a question earlier from Judge Moore, and Judge, you were talking about audio tapes and what was construed, and ultimately, Your Honor, I believe that you then stated that at trial, is it safe to assume that Detective Monteleone's testimony was not believed by the trial court? What I think happened in between was also adduced at hearing was testimony from Detective Tamika Agnew, who was also of the Cuyahoga County Sheriff's Deputy. And she was considered the quote-unquote handler of Ms. Bell. And she had reported conversation with Ms. Bell in which Ms. Bell detailed this idea that I don't believe is parsing words as much as the state would have us believe, but were really critically important. And those words that were reported were that, in fact, Ms. Bell had gone to Detroit and in a circumstance completely unrelated and ultimately admitted to from the detectives at hearing, unrelated to anything involving Mr. Jackson, had made a purchase of a large quantity of narcotics, and that Mr. Jackson had nothing to do with that, and that if anything, it would be her drugs that she would be retrieving. And that was very well known to Detective Monteleone, the affiant. And ultimately to the point of where at some point on the tape reporting of that conversation, Detective Agnew is debriefing Detective Monteleone prior to the warrant composition, I'm sorry, the affidavit composition, I should say, wherein which Detective Monteleone seems to interject his own wording and saying, okay, so you're able to purchase these drugs from Mr. Jackson, or Mr. Jackson is holding a large quantity wherein which you can purchase a independent quantity from him, and she very clearly states no, and Detective Agnew very clearly corrects Detective Monteleone and says, no, that's not the situation at all. Nonetheless, what happens regarding the affidavit, as is in the record, is that Detective Monteleone goes to great lengths to describe this as controlled purchasing, that Mr. Jackson had purchased a large quantity of narcotics in Detroit, and that he was holding a smaller quantity for purchase from Ms. Bell, and so on and so forth.
Was there actually an exchange of money when she was in the driveway?
Absolutely not.
There was no money exchange?
Absolutely
She
not.
the package and walked away?
Well, and there's somewhat of a dispute. There is absolutely no exchange of money. There's nothing that would ever, after the fact, symbolize a purchase in any way. But nonetheless, in the composition of the affidavit prior to, there certainly should have never been the call to be placing language that would suggest that A, Mr. Jackson was somehow involved in a narcotics transaction with Ms. Bell in any location, nor that there would be some form of controlled purchase that had ever been investigated in between prior to the search warrant occurring. There were also questions regarding the recordings themselves, in furtherance of the cooperation of Ms. Bell. One of the things that, and I don't want to take the court too far away from the sum and substance of what we're here for, but one of the concerns throughout the case was Ms. Bell had structured Ms. Bell's identity was enlarged for a large portion of the case, kept anonymous despite motions to reveal and ultimately motions to compel and whatnot. And much of the reporting that has been inquired about was not revealed until well later and frankly close to the setting of the hearing itself. In fact, and counsel correctly points out that initially, because of some of the difficulties regarding 16 discovery, and I don't point that towards the state itself as much as I pointed towards the detectives in terms of the information that was withheld, it became incumbent to press the secondary issue of revealing the identity of the informant or alleged informant or whatnot so that we could in fact do what happened ultimately, and that was to supplement the hearing with the affidavit. And within the affidavit of Ms. Bell and that supplementation, there is very clearly a statement from her indicating that she did not participate in a controlled purchase of narcotics as we reported.
So the case law seems to be pretty clear that if the court finds information in an affidavit that is false, that it can excise that information, and then its role is to review the balance to determine whether or not it supports the charge. What in the court's entry suggests that the court did that?
Well, and I believe, Your Honors, and I, although possibly ineloquently, I believe that I tried to include portions of the record wherein which the trial court was in fact indicating having excised portions of Detective Monteleone's affidavit that he considered to be false and or at least within a reckless disregard for the truth, that the affidavit within it could not stand.
Well, it made a conclusory statement, I'll give you that, but there's really no analysis as to, what the court considered was remaining.
Well, and with all due respect, Your Honor, I believe that I understand what you're saying, the remaining portions and where that, okay. So I think, Your Honor, that if you excise the portions wherein which the affiant was referring to these ideas of controlled, having watched it, while having understood the transaction, having had eyes on it, still to come back and characterize this as a narcotics transaction, a purchase, a pickup, and also to have included background information that was also, frankly, patently false, based on information that his own colleagues had provided him and made him abundantly clear of. After that, although I do believe the court needs some reference to what we all refer to as boilerplate subjects within an affidavit, I believe that the court's analysis was, after that, there was not much less. Once you've taken out Detective Monteleone's, if we want to talk about conclusory statements, certainly, I would say, fanciful statements, things that didn't happen.
Well, okay. But it does not remove the fact that Ms. Bell wore a wire, had whatever conversation she had with Jackson, took the police to the location, received a package from him, and that package was examined and tested and, presumptively showed drugs. The fact that she said she never agreed to be a confidential informant and that he did not pay her, that there was no controlled purchase, does not take away from the fact that she went and got drugs from him.
I understand the court's query very well, and I apologize further. What I believe the analysis that was occurring, and what I believe that the transcript also revealed, is that there is I think we can all agree that under the mandates of Berger and our lineage of probable cause, we have to have indicia of an idea that evidence of a crime or contraband is likely to be located. And I think that what the affiant was intending to do was to paint a picture of Mr. Jackson as a large-scale drug dealer. I think that the affidavit portion that becomes very critical in the analysis is when he makes painstaking reference, despite it being patently untrue, to the fact that there was a large quantity that was supposedly purchased by Mr. Jackson in Detroit, and that Miss Bell was going to retrieve or purchase a smaller quantity from him, which laid, I believe, at the issuing magistrate's feet this idea that, well, obviously then, if there was a lesser portion or a greater portion in general, and a lesser portion purchased, that there is a large likelihood that the remains of the illegal activity would be in the place. Whereas when the truth, frankly, that was stated well prior to even the constructing of the affidavit was simply that whatever quantity that Ms. Bell had purchased, independent of Mr. Jackson, and had housed with Mr. Jackson, and frankly, one of the other interesting issues is there was talk although it is very difficult to follow from the reporting and frankly the testimony, and I've spent a very long time with this, there's talk that the retrieval actually occurred he opened the hood of a car and retrieved the package outside of the residence, frankly, and that package was then allegedly handed to Ms. Bell. So, Judge, I don't know if I'm not being evasive in any way. I hope you understand, but I don't know if that answers the query that you're looking for.
I was left with the impression after reading the briefs that the court just didn't believe the witness, and if the court and with good reason, that if the court could not find the detective credible on major issues such as whether or not this purchase took place once he was even corrected by his colleague, that he could not be believed regarding anything else. But having said that, that doesn't answer the question of whether the court then went on to make the appropriate analysis, given the testimony of the other witnesses, that there was enough evidence to support the charge.
Well, and I certainly appreciate the mandates of Franks and Prodney thereafter that describe a process, although as opposed to, I think we all enjoy our various bright line rules or our two-pronged tests or things of that nature, our Blockberger test things. But when it comes to that analysis, I don't know that there is a bright line rule other than, and I know that you refer to the trial court making somewhat conclusory statements regarding, and I believe that the judge said, when I excise or when I extract those portions, I'm left with an affidavit that simply does not suffice in my conclusion. And I don't know, Your Honor, how to answer the question in any other way than I believe that is the analysis that he undertook. And I do believe that there is a significant backdrop that, frankly, Franks does require, that once you have walked into a place where a hearing is mandated, and I think clearly there was enough inconsistency going on here that a hearing was required, that analysis is somewhat of a conclusion based ultimately on our star witness, who's the affiant, because he's the only person who could be responsible or could understand what it was that he swore out and what it was he said. Now, obviously, it's very unlikely that any affiant is going to say, and what I really wanted to do was I wanted to go and see Judge Schaefer, and I wanted to kind of hoodwink her into signing an affidavit because I've been well-trained and I know what's... I'm sorry, Your Honor.
You need to conclude. You've now at your 0 time.
I will only say this. I do believe, obviously, and I thank the court for the questions this morning. I do believe that the exploration of Franks is always an interesting topic. I believe that the hearing was a full and fair one. Thank you.
You have your 3.
Thank you.
Sorry.
I guess the first thing I want to address is the factual issue of where Jackson actually had the drugs from that he delivered to Bell. My reading of the transcript from the hearing was that he actually left his residence with the drugs, went out to Bell's car, provided that package to Bell that was later tested and field tested for heroin, and that he then, after he left Bell's car, went to another car that was parked outside, picked up the package, and then went back into the residence. So my reading of it is that he actually had the drugs within the residence that he provided to Bell during that pickup. And I think Judge Moore is correct in that the trial court stated, didn't go through the analysis of the remainder of the affidavit that he determined that he did not find to be false at that point to determine whether or not there was sufficient probable cause when those excise portions were removed. We did, and contained with that is the recorded phone call that she made to Jackson, her actually taking the detectives following her providing the directions as she was going to Jackson's residence. The exchange that was actually witnessed by the detective that was conducting surveillance at Jackson's residence, and the ultimate fact that the substance did in fact test positive for heroin.
So let me ask you this.
Yes, sir.
There are a number of drug charges that were filed on which Jackson was indicted, and you set them out in your statement of the case. The trial court doesn't appear to go through the various charges to determine whether there remains sufficient evidence on, for example, one count of possession of drugs, but not on the other. You see what I'm saying?
Yes, Your Honor.
So the entry just says, basically the entry just says that the defendant's motion to suppress is granted. But at the hearing, does the trial court discuss the different counts?
There was a very brief discussion, not in each individual count to say this particular piece of evidence goes to this count, but a very brief discussion that there was trafficking charges, but maybe not possession charges for the heroin. So there wasn't really a discussion or an understanding of how each piece of evidence would fit in with each particular count. So no, we do not have that on the record.
And I'm sorry, but you have now used up your time.
Thank you, Your Honor.
And we will take the matter under consideration and send you a copy of the written opinion when it is issued. You can always find it also on our webpage. Thank you for coming here today. We are adjourned.
Thank you, Your Honor.
Honor.